Okay. So good morning. Today I am going to talk about the use of non-judicial settlement agreements under the new Wisconsin Trust Code, or relatively new Wisconsin Trust Code, which became effective in July of 2014. I'm going to go through kind of the way that this presentation is set up is more like a thought process that you would go through in determining whether a non-judicial is appropriate in any given circumstance. And it starts with kind of the threshold issues, which give you a kind of a yes or no answer, and then goes into some more details about the kind of things you're going to need to think about in determining if it's going to be a possibility to use a non-judicial. So non-judicial settlement agreements prior to the enactment of our new Wisconsin Trust Code were not permissible under our law. Now with the new Trust Code, there are specific provisions which allow us to enter into non-judicial settlement agreements. In the past, the only way to bind individuals to an agreement related to a trust was through a contractual obligation, and we didn't have representation provisions which would allow us to bind more remote, more contingent beneficiaries. And so most of the things that we wanted to do with respect to irrevocable trusts, we could only do through a judicial process. Now that we have non-judicial settlement agreements, we have a lot more flexibility. So we're going to start with jurisdictional issues. The jurisdictional issues are you first need to determine the governing law and the principal place of administration for the trust at issue. The governing law is important because it determines the meaning and the effects of the terms of the trust, including the identity of the beneficiaries, the extent of their interest, and the allocation of income and principal. The governing law is basically the substantive issues of the trust. And typically that's included in a trust document or a will that would create a trust. It would talk about where the governing law is. Ultimately, the distinction between governing law and principal place of administration, which I'll go into, makes a difference because it determines what court you're going to be in if you have to go into court, and it also determines which rules apply. So governing law, if you're going to think about doing a non-judicial with respect to any of the interests of the beneficiaries, the allocation of income and principal, or the identity of beneficiaries, that will be governed in accordance with the state law listed as the governing law in the trust document. For principal place of administration, the principal place of administration governs administrative matters, including state tax reporting obligations in some states, the court's jurisdiction, and the laws governing administration of a trust. So if you have a question, if the non-judicial is going to be something related to the administration, like a direction of the trustee to do something, that would really be a principal place of administration question, and so you'd have to look at where the trust is being administered to determine which law controls in that regard. So most times you're going to have a document that says where the governing law is, what law controls. But in situations where there is no governing law as listed in the document, it's the law of the jurisdiction having the most significant relationship to the matter at issue. So if all your beneficiaries live in Wisconsin, if the settler or grantor of the trust resided in Wisconsin or still does reside in Wisconsin, if the trustee is also located in Wisconsin, all of that has a significant relationship to Wisconsin. And then you look at what the matter at issue is. So if you're determining whether or not there's an ambiguity in a document or the extent of the beneficiary's interest, and again, you have everybody who's residing in Wisconsin, most likely that Wisconsin is the governing law for those purposes. Principal place of administration is the trustee's usual place of business. Now that applies to corporate fiduciaries. So For individual trustees, it's going to be where the trustee resides is going to determine the principal place of administration for the individual trustee. So once you've gotten through the threshold issue of which law controls and where your principal place of administration is, and you've determined that it's Wisconsin with respect to the issue at hand, then you next want to look at when is a non-judicial settlement agreement appropriate. And under our new law, a non-judicial settlement agreement is valid. You can enter into a non-judicial settlement agreement with respect to any matter involving a trust, but it's only valid to the extent that it includes terms and conditions that could be properly approved by a court. And so that's a very broad standard. Pretty much anything a court could do, you could do by non-judicial. And so I guess the threshold is very wide for that, but we'll talk about more of the limitations as we go forward. It kind of, the way this presentation is structured is it goes through the bigger picture and then narrows down into some of the smaller issues that will need to be considered. And so some things that people might ask, what are the things that may not be properly approved by a court? Well, one example of that would be something that would violate public policy. So if beneficiaries or grantors wanted to enter into a non-judicial settlement agreement to modify a trust to encourage a beneficiary to get divorced from their current spouse, that's a violation of public policy, and that's something a court wouldn't approve, and therefore you can't do it by non-judicial. If there are any questions relating to whether a court could properly approve it or whether a non-judicial is appropriate, including who are the necessary parties and whether any representation that's incorporated into the non-judicial is appropriate, any interested person can request court approval of that non-judicial. And so what that would look like, practically speaking, is that the interested parties would enter into a non-judicial settlement agreement, and then from there they'd file probably a simple petition requesting that the court just stamp its seal of approval on that agreement to make sure that there aren't going to be any issues going forward. And we'll talk about the reasons maybe why you would want to do that down the road as far as enforceability and validity. All right, so once you've determined that you have your governing law and that and your principal place of administration worked out, and that a non-judicial involves a subject matter that could be properly approvable by the court, let's talk about some of examples of what those permissible subject matters would be. In our new trust code, it lists a non-exclusive list of permissible subject matter, and I think from what the drafters of the code have said, it's more of examples to give some guidance as to what would be included, but it certainly is not exclusive. So just to go through some of these, you can enter into a non-judicial to interpret or construe the terms of a trust. If there's an ambiguity in the document and all of the beneficiaries and all of the interested persons agree as to how that ambiguity should really be interpreted, instead of going to court, you can have all interested persons enter into a non-judicial and accomplish the same thing. You can have a non-judicial approve the trustee's accounting, direct the trustee to take a certain action. So for example, if there's a beneficiary who needs a sizable distribution and that distribution for one reason or another may seem a little bit more risky to the trustee, maybe given because of the dynamics of the parties, that they normally wouldn't be so certain to just make a distribution like that, you can enter into a non-judicial to direct the trustee to do it and release that trustee from any liability related to that direction. Other permissible subject matter includes resignation and appointment of a trustee, determining the trustee's compensation, and transferring the trust principal place of administration. It also includes issues relating to liability of the trustee, like I just mentioned. If the trustee is concerned about an action that the trustee is going to take, and the trustee wants to make sure that there's not going to be any consequences or repercussions for that, we can enter into non-judicials to release that trustee of liability. We can resolve disputes among beneficiaries and other trust parties, appointment of and powers granted to a directing party or a trust protector. Now, this last point is important and is often used recently in non-judicials because we have a lot of already existing irrevocable trusts that that really have either been administered, for decades and don't include trust protector or directing party language, or were recently signed just before the trust code was enacted, and also similarly don't include these new types of parties. And so now with non-judicials, you see a lot of interested persons entering into them to appoint a directing party or a trust protector for a variety of reasons, mainly because these two types of parties add a lot of flexibility to a document and just give more flexibility for going down the road. When you have ongoing irrevocable trust that's supposed to last for several generations, these are additional safeguards that you can put into place to make sure that the grantor's intent is going to be honored. And given the dynamics of the parties involved, you might want to use these provisions for various reasons. So for example, directing parties, you can now appoint directing parties to allow for the distribution decisions related to a certain beneficiary or investment decisions related to a certain asset. And the reasons you might want to appoint a directing party would be, for example, if you have a beneficiary who perhaps is difficult, you might want to have a directing party make the distribution decisions for just that beneficiary. Or if you have a family business and one of the children is very involved in the family business and the rest of the children are not, the grantors may want to appoint a directing party, namely that child who's involved in the family business, to manage that asset, the business asset that's held by the trust. It might be that the child isn't appropriate to act as trustee over all the assets, but specifically related to that business asset, it makes sense. And so now with directing parties, it's a bifurcation of fiduciary liability, and it allows the grantors and the settlers to have more flexibility in deciding who's going to be managing what assets of the trust. One other thing to note, although it doesn't list trust modification as a permissible subject matter, it's been widely discussed that that's not an exclusive list, and so most times when we're using non-judicials these days, we're modifying previous trusts to include various provisions, settlers, directing parties, modifying the trust provisions, some administrative provisions, just to make them more relevant. There's a lot of trusts that we administer that are very old, and sometimes the trust provisions don't really make sense for the beneficiaries. And so now with non-judicials, we're using them to modify some of those provisions to make them more relevant. So once you determine that you have a permissible subject matter, the next step is to determine who the beneficiaries or the necessary parties are. And under our new trust code, we have a lot of definitions that we didn't previously have. And so we have just first the beneficiary. And the beneficiary is important because under the statute sections, they define who would be interested. In a lot of cases, it defines who notice needs to be given to and who would necessarily be interested for purposes of a non-judicial or for a judicial proceeding. And in certain cases, you'll see all beneficiaries, and in other cases, you'll see the term qualified beneficiaries. And so when it says all beneficiaries, that means everyone. So current beneficiaries, more remote beneficiaries, contingent remainder beneficiaries, beneficiaries who probably would never ever have an interest, but if everybody in the family and the line of blood passed away, and then they would take something, but that would be all beneficiaries. Qualified beneficiaries is defined specifically under the law, and that is a current beneficiary who's entitled to principal or income from the trust, and also any beneficiary who would take if the current beneficiary's interest terminated or if the trust terminated on a given day. And so you have to look at, it's kind of a snapshot of time, you have to look at who would fall under that definition at the time that you're looking to enter into the non-judicial settlement agreement, and that will define who are the necessary parties to the agreement. Directing parties are those that I just discussed, individuals who have been appointed to make distribution decisions or investment decisions related to an asset or a beneficiary. The settlor, also the grantor, the creator of the trust in certain cases, depending on what statute section is relevant for the non-judicial, you may have to have the grantor of the trust be a party to it, and also the trust protector. All right. So, because some of the statute sections, for example, the easiest one to talk about is the modification statutes. The modification statutes under our trust code say that if the grantor is alive, that a trust can be modified, an irrevocable trust can be modified with the consent of the grantors and all of the beneficiaries, even if it violates the material purpose of the trust. If the grantor is gone, or you can't get the grantor's signature or consent for a modification, all of the beneficiaries can modify a trust if a court could conclude that it doesn't violate a material purpose of the trust. And so when you're dealing with ongoing trusts, more times than not, you're going to have provisions that say for the benefit of issue and more remote contingent beneficiaries, future generations. And most times, those individuals are either not born, are minors, or are unascertainable at the time that you want to enter into a non-judicial, which is why in the past you couldn't modify a trust without court approval because we didn't have representation provisions that would allow for it. Now we have representation provisions, and these representation provisions allow us to represent necessary parties in the non-judicial settlement agreement. So adult ascertainable beneficiaries can represent their children, more minor, more remote beneficiaries who may have a substantially identical interest, who may be subject to the beneficiary's general power of appointment. There's a variety of ways that we can go about getting representation of those individuals so that you can have all necessary parties be a party to the non-judicial settlement. When you have representation and it's appropriate, it's binding on the represented party. So it's as if that minor, unborn, unascertained individual signed the document themselves. The trustee, however, even if you do have representation, is not going to be liable for giving notice, information, or an accounting to a represented party. Now, I will note that these provisions are default provisions under the code, and so to the extent that your trust document specifically delineates the role of representation in it, which it might now going forward, if you have new trust after July of 2014, you may have representation provisions in your trust documents that you're reviewing, but previous documents likely will not include this. And so it's important to note that to the extent that the trust document delineates the role of the designated representative and the represented party, the trustee is obligated to follow those instructions, and that these rules that I'm talking about are default rules in the absence of the trust saying otherwise. So some examples of how representation may be effectuated is a holder of a general power of appointment can represent everyone subject to that power. Fiduciaries, agents, and guardians can represent in certain circumstances the principles for which they're acting. For parents can represent and bind minor and unborn children. The trustee in certain circumstances can appoint a representative for beneficiaries. It depends on what what the subject matter of the non-judicial is. For example, I'm not sure that I would recommend that a trustee appoint a representative to represent beneficiaries in approving a trustee's account. It's a conflict of interest, and it wouldn't likely be permissible under our code. You can also have representation of a person with a substantial identical interest. So if you have a class of grandchildren who are beneficiaries, and some are adults and some are minors, the adult grandchildren can represent the minor grandchildren. And you can also have a representative appointed by the court. So in the past, we just had guardian ad litem in judicial proceedings, and the court would appoint a GAL to represent minor or unascertained beneficiaries. And now you can just request that the court appoint a representative, and the only court process would be related to the actual appointment of a representative, and then the representative would act non-judicially in becoming a party to this settlement agreement, which is a new option in Wisconsin. It's important to note that all of these representation provisions are only available to the extent that there's no conflict of interest between the designated representative or the nominated representative and the represented beneficiary or individual. Conflicts of interest are must be analyzed on a case-by-case basis, and it's not just simple conflicts that are staring you in the face. It's more the dynamics of the parties, any information that you have that would make it likely that the person who's purporting to represent another person may be not appropriate for the circumstances. One of the more obvious examples is in a marital trust. You might have a surviving spouse who has a general power of appointment on his or her death. And under our trust code, it says that a holder of a general power of appointment can represent everybody subject to that power of appointment to the extent that there's no conflict of interest. Well, let's say that the surviving spouse wants to modify the terms of the marital trust to allow for increased distributions to that surviving spouse. It would not be appropriate for the surviving spouse to represent everyone subject to that general power of appointment, because all of those individuals are the remainder beneficiaries. And so because the surviving spouse wants to increase his or her distributions to the detriment of the remainder beneficiaries and the more remote beneficiaries, it's not appropriate for that surviving spouse to represent those beneficiaries who would not benefit from this non-judicial. That's a conflict of interest. Some of the not so obvious conflicts of interest may be family dynamics. So if you have a situation where individuals are estranged from certain family members, it's likely a conflict of interest for some of those individuals to represent other individuals who they are estranged from. So it's important when deciding if you have appropriate representation to look at all the aspects and confirm that not only kind of on its face you don't have a conflict, but also with regards to dynamics and the situation involved that you're not going to have any conflicts of interest. And so the reason that representation is really important to analyze is because if you don't get the representation right and the representation isn't adequate, you're going to have an invalid non-judicial settlement agreement. And there's other situations when you may not have a valid non-judicial. As I talked about in that example before about if you're going to enter into a non-judicial to violate public policy, that's going to be an impermissible subject matter, and that would make your non-judicial invalid. Also, again, if you're missing necessary parties, which means that they're not represented and they're just not signatories on the agreement, that's going to also render your non-judicial invalid. Finally, if you have inadequate representation, that's going to cause your non-judicial to also be invalid. So what happens when a non-judicial is invalid? A few things. A non-judicial that has impermissible subject matter is just unenforceable. It's void. To the extent that you attempt to enter into it, it's not binding on anybody, and it may result in some issues down the road if somebody's administering, a trustee is administering a trust in accordance with an impermissible subject matter. If you have a non-judicial that has missing or inadequately represented parties, it's unenforceable against the missing and inadequately represented parties, and it may or may not be enforceable against parties who signed it. There is unpublished case law in the state of Wisconsin that says that if the parties are missing, that it's not an enforceable agreement. And so, you know, when entering into these agreements, it's important to make sure that you've checked all the right boxes, that you have the representation, that you have the necessary parties who are adult and ascertainable, that the subject matter is permissible, that your jurisdictional issues are answered, because ultimately if you go through the process and you're missing any of those pieces, you're going to render your document invalid, and that's not going to accomplish ultimately your goals. So one of the issues is then for trustees who are administering trusts, what is their liability when they're presented with a non-judicial settlement agreement or they're a party to a non-judicial settlement agreement? And you know, one of the issues is for a trustee, if you're administering an invalid document, you may have claims against you for breaching your trust even if you didn't realize you were doing it. Under our new trust code, we have a new specific statute of limitations that limits the liability of trustees for administering trusts and for breach of trust claims. And the statute of limitations is 1 year, and that's 1 year from the date that the beneficiary or representative was sent a report that adequately discloses the existence of a potential breach of trust. An adequate disclosure, in turn, is defined as sufficient information so that the beneficiary or representative knows of the potential claim or should have inquired into its existence. And so for non-judicial settlement agreements, this may be one reason why you might want to get court approval, because this will allow your statute to run. It will make sure that all of your beneficiaries and that your representation and your necessary parties are party to the agreement, and it will allow you to have some sort of comfort in the fact that the non-judicial is a binding agreement. To the extent that you can't get the 1 year limit to run, or that it does not apply, a claim for breach of trust must be commenced within 5 years after the first to occur. And that's the removal, resignation, death of a trustee, the termination of the beneficiary's interest, or the termination of the trust. And 5 years, I think, on first impression doesn't seem like a long time, but the issue is when you look at the specifics related to from the first to occur of, those may not happen for decades. And so, for example, when you have a corporate fiduciary who's acting as trustee, sometimes they will act for decades. And then the termination of a beneficiary's interest. In a lot of trusts, we have trusts that are for the benefit of a beneficiary for the beneficiary's lifetime. And so the trust, the interest of the beneficiary may not terminate for 40 years. And if you have a corporate fiduciary, that corporate fiduciary may act the entire time. And so, it would be 5 years after the first to occur of that. So it could be 40 or 50 years down the road. And most trustees don't want to leave that liability hanging out there for that extent of time. So to the extent you can give adequate disclosure, that you make sure that everybody who is necessary is a party to it, that they sign off, that they are aware of the terms, they have the opportunity to review it, have their own counsel review the non-judicial, the better, because that gets your statute running. As I mentioned, with these non-judicial settlement agreements, because you're going to be getting the consent and the signatures of all of the interested persons, a beneficiary's consent, release, or ratification to any of these types of non-judicials will be binding, and the trustee will not be liable unless it was induced by improper conduct of the trustee or the beneficiary lacked knowledge of the beneficiary's rights or material facts relating to the breach. And finally, we do have one last trust provision that allows a little leeway for trustees, and that's the reliance on the trust instrument. And for non-judicial settlement agreements, once they're entered into and they're validly entered into, they become a part of the trust agreement. And so a trustee who acts in reasonable reliance on the terms of the trust is not liable for a breach of trust to the extent the breach resulted from reliance. Now, this reliance may not be justified when the trustee is aware of the terms of the trust have been clarified or changed by the court or a non-judicial settlement, or the trust is ambiguous and the trustee relies on one of several meanings. I just had a situation recently where the trust provisions contained some ambiguous terms in that you could have determined that a share for beneficiaries when the grantor died could have gone one of two possible ways. And in that case, the trustee, we petitioned the court for instructions to interpret that ambiguity because, again, you can't rely on the trust instrument when you know that there's an ambiguity. Now, in that case, we had a lot of beneficiaries and the dynamics were strained amongst the parties, and so for those purposes, a non-judicial would not have been appropriate because we likely couldn't have gotten all of the necessary parties to sign off. So instead, we petitioned the court and gave notice to everyone, and the court construed the trust to resolve the ambiguity. And so now the trustee could rely on the provisions as construed by the court order, and this trust provision would apply. So I guess to summarize, as I mentioned before, it's important when you're thinking about entering into a non-judicial, all of those various issues. So you want to consider your jurisdictional issues, the governing law, the principal place of administration, the subject matter, whether or not it's a permissible subject matter, consider who the necessary parties are. A lot of times that will be delineated in your statutes under which provision you're going to go under. And then consider whether or not you have representation of any minor, unborn, unascertained individuals. In certain circumstances, you can have adult, competent individuals represented. It's always important to review the trust document because, as I mentioned, the rules I just went through are always default provisions. And so to the extent the trust provides otherwise, the rules that I just talked about may be modified pursuant to the trust, and so it would be important to follow the terms and provisions of the trust document. Any questions? I know.
Get a few from the webinar.
All right. So one of the questions is there a reason why you might still request a court order even if a non-judicial settlement agreement is entered into? And I think I mentioned this, but yes, there is. You can request a court order to confirm that the non-judicial is valid and binding, to confirm that representation is appropriate, that all necessary parties are party to the agreement. Also for purposes of appealing any sort of, or challenging any sort of issue with the non-judicial, you can likewise get a court order, and it just adds a little finality to it. Oh, I don't know how I'm going to manage that. The next question is, how does the new trust code impact old trust documents? And the new trust code applies to old trust documents. There are some effective date provisions that that will not apply to trusts prior to July 1st, 2014. Those primarily relate to duties to inform and report by a trustee. So the duties to give specific information to beneficiaries and how the trustee goes about giving it. There's some other provisions that are what we call effective date provisions that would make a difference. But for the most part, the new trust code applies to all existing documents. And so with respect to non-judicial settlement agreements, you can really add in, you can use the new trust code to do things related to existing documents. How are you seeing non-judicial settlement agreements used most? So I think for the most part, we've seen non-judicials used most for, number one, trust modification. A lot of pre-existing trust documents, as I mentioned, aren't always relevant anymore. Some of the administrative terms don't make sense. Some of the trustee provisions may not make sense. And so a lot of times beneficiaries and grantors are coming to us and saying, what can we do with this existing document? How can we change it to make it more relevant going forward? And so we've entered into a lot of non-judicials relating to trust modification. The other primary use we've seen non-judicials being used is approval of accounts and administration of a trust to release a trustee of liability, and then finally to add those directing parties and trust protectors into trust documents. With the directing parties, a lot of families who have family-run businesses or difficult beneficiaries are really finding that the directing party provisions are very beneficial for their circumstances, and so we've been using those to add in those provisions and build in some more flexibility. Yes?
Back to the court approval.
Mm-hmm.
If you're going through the exercise of getting court approval anyway, why even start with that?
I think okay. So the question is, for non-judicials, if you're going to go through the process of getting court approval, why wouldn't you just do the whole process through a judicial proceeding instead of entering into a non-judicial? And I think the primary reason for that is because the non-judicial settlement agreement can contain more details, have more dispositive provisions included in the actual agreement or the attachments to the agreement that then you might want to redact out of the pleadings for the court process, and so it can build in some privacy for people who are concerned about too much information being of public record. So a non-judicial settlement agreement can modify one specific provision of a trust, for example, the trustee provisions. And instead of reciting the whole terms of the trust in a court pleading and then asking the court to just modify the administrative provisions, you can include the non-judicial as well as the redacted copy of the trust agreement and request that the court approve the non-judicial based on what's been provided to the court, and a lot of times an affidavit from the drafting attorney, saying that the trust agreement as redacted is what it is. But that would help the clients build in some protection. And we have, a lot of clients who are concerned about, I don't want all of my private information to be of public record just to accomplish a change of trustee or to, have the trustee take a certain action. I don't want all of my business that I thought was private and why I put it into a trust to be made public record. Anything else?